Well, chances are your company has a lot of at-will employees. So with Georgia, South Carolina being a right-to-work state, and we have an attorney that handles various situations in both states. Brian King, how are you?
I'm doing well, thanks. Thanks for having me.
Sure. I know there are certain types of employees that are under what's called non-compete agreements.
That's right.
Before we get started on the enforceability, what types of employees have you come across that are being asked to sign this?
Well, sales employees, because they've got a lot of contact with your customers, and so if you don't want them leaving your employment and going to work with someone else and taking those customers with them, so sales employees is probably the number one.
Makes a lot of sense. Yeah. And there's always a question about. I know when I was in the TV news business, boy, we couldn't go to another station within the same TV market for a period of, and I always thought, well, that's fine if I want to go outside the area, but what if I want to stay in Augusta? What seems to be the right term that is fair?
Right. Well, the enforceability of non-competes is a big issue, and I get asked that all the time by both employers and employees. And so, traditionally in Georgia, the non-compete agreements weren't enforceable to the same extent that they are now. Georgia actually had a public policy against restrictions on employment, or someone being able to go to another job. And around 2011, that changed because Georgia passed a constitutional amendment and then a statutory framework for non-compete agreements and what they had to contain and how they were going to be enforced. And so once that happened, the Georgia courts have now been enforcing non-compete agreements to a much larger extent. So it was a sea change in that realm of the law. And so the restrictive covenant, so non-competes, have to be reasonable. The restrictions have to be reasonable, and the way that the courts look at those restrictions and determine whether they're reasonable, they have to be limited in scope. So the scope of the work that is being restricted. So it can't just be you can't go work for anyone doing anything. It has to be limited to what that employee was doing for that particular company.
And you mentioned sales, so let's just say I said media before, let's say someone is in media sales and they want to go sell copy machines in our town. Is that okay?
Right. If it's something completely different and the employer where they're at right now doesn't do that type of work,
okay,
then there should be no restriction on them to go do that work in another area. So So the non-compete provisions also have to be limited in geography. So as you mentioned, this particular area, the CSRA, or you can even limit it by county. Say, Columbia County, Richmond County, Burke County, that sort of thing. Or you can do it by square miles, or you can do it by radius. So you can say a 5-mile radius, 10-mile radius, something like that. And it has to be restricted to the area which that company is doing business in.
So if someone was selling cars in Richmond County, Georgia, on Washington Road, and they wanted to do the same thing, but maybe it's in Aiken, or maybe it's a little further into South Carolina, that potentially could be okay?
Well, potentially could be okay into South Carolina if, as you know, the CSRA, we're so, it's just the river dividing South Carolina and Georgia. Yeah. So a lot of times the companies do sell to, Aiken County and Edgefield and that sort of thing. So it could be enforceable as long as the company is selling to that area. But it wouldn't be reasonable for them to say, well, you can't go sell in Kentucky if the company has never been selling there.
Sure.
And then also to be a reasonable restriction, it has to be limited in time. And as you were referencing, with an employment agreement that has a non-compete provision or a non-compete agreement, it has to say that you can't do this work for X amount of time. And typically what's been upheld by the courts is a 2-year limitation. So it can't go beyond 2 years. But anything 2 years or less would be considered reasonable in an employment context. Now that can differ if it's a sale of a business context. So let's say someone is selling their business and they agree to a non-compete for a period of time so that they won't get back into that business after they've sold the business.
And you know what? That happens. I mean, even with me, with Buzz on Biz, years later,
Right.
I'm doing something similar. But you do see, I know someone that was in the IT space, sold a company. He's restarted under a different name, but apparently it met the scope and time and distance and all that.
Yeah.
So it does happen.
Yeah, and in the sale of a business context, the courts have upheld 5-year restrictions and said that is sufficient and or satisfactory. Beyond 5 years has been stricken down before, and so you've got that longer time period of restriction with the sale of a business context.
We're continuing with Brian King, who services clients in Georgia and South Carolina, offices in Atlanta and Augusta. Online, businessattorneylaw.com.
Right.
Businessattorneylaw.com. Have you been witness and have had to go to court on these kinds of things before?
I have.
And how has the judge typically ruled in this situation?
Yeah, well, it really just depends on the situation and what's going on in that case. But I mean, I have represented, I've represented people, in employees wanting to go work somewhere else, and I've also represented employers who were saying, "Hey, you can't go work somewhere else, and you can't go work for that particular company because they're a competitor of ours." And so it's, you really have to dig down and look at the facts and circumstances of each case and what that employer was doing when they, left the company and what they're doing now and how competitive is it, that sort of thing. And, but I also, I draft a lot of the non-compete agreements, for my clients, and it really does take some care. You have to draft them pretty carefully, or otherwise they're not going to be enforced. And so, and because I've had that litigation experience, with those provisions, I've been able to craft my provisions very tailored to make them, a lot better chance of being approved by the courts versus being stricken. So
and then are there times at the end of the day, if the employer says, "I want you to sit out for a year and a half," and the employee says, "I want to sit out for 6 months," I mean, is there just a win-win somewhere?
Well, sometimes, I mean, sometimes they do settle on some time frame that would work, and sometimes the employer may sue just to stop the employee from being able to work while the litigation is pending. Sometimes by the time the litigation is over, the restrictions run. And so in my documents, I usually have provisions in there that say that it will toll while the litigation is pending, and then it will start back after the litigation is pending. So there's provisions you can add in there to give the employer more protection and stuff. So, it's a little bit of gamesmanship goes on with the litigation when it comes to because you're dealing with, say, employee that's gone to a competitor, and if that's going to hurt your business, sometimes they do what they can to try to minimize that. But they take a risk though, because they're going to court, and they could get slapped on the wrist by a judge for bringing something that wasn't really something they should have brought.
Fair enough. Well, he is Augusta Business Daily Attorney, Brian King, and it is businesslawattorney.com for the website. And boy, I think this is the first time you've been back in the studio since there's been a few changes. What do you think?
I think it's good. I like the lighting. It's better than it was before, and it's businessattorneylaw.com. Yeah,
that's what I said. businessattorneylaw.com. Well, we are very pleased to mention about, the podcast folks, and you can get on up, if you will. Ode to James Brown, getupproductions.com is the website, the umbrella company of the podcast studio here, and all of the information is up on the screen. Well, if you've ever signed a contract, you probably know that there has to be a way to settle things at the end if things go the wrong way. And we are with Augusta Business Daily Attorney and Business Attorney Brian King. I'm Neil Gordon. How are you, sir?
I'm doing well, thanks.
There's always some little clause at the end of a contract, and it, because let's face it, things could go to arbitration, things could go mediation to court. What is a typical clause to resolve a contract?
Yeah, well, there should be those dispute resolution provisions in a contract, because in the event that there is a dispute between the parties, it's better to have a way of resolving it. Sometimes the parties choose mediation, followed by, if mediation doesn't settle the dispute, followed by arbitration, binding arbitration. So mediation is something that is not binding. It's where you go, you talk to a mediator, and the mediator tries to help you resolve your differences and come to some settlement. And but sometimes that doesn't work. Sometimes people just don't want to settle for those things, and so either arbitration or going to court is usually the sort of last resort on those things. And and sometimes arbitration can be cheaper than going through the court. Sometimes it can be faster. You have certain rules in arbitration that you follow depending on what arbitration procedure you choose to follow, whether it's AAA or another entity that's putting on the mediation or arbitration. I mean,
Sure.
And if and so those procedures are going to be followed, and it can lead to a faster resolution than in court. I mean, courts are backed up with
Sure.
criminal cases, and those are going to take some priority because you've got people sitting in jail, and so there's sort of a backlog of civil cases, and it makes for slow justice in some cases.
Now, is it an arbitrator or is it an arbitration panel?
It can be either one. You can have one arbitrator, or you could have three. It's really just depending on where you're
Tiebreaker, I guess.
Where you're doing the arbitration and what rules they have, and obviously you're going to have to pay for the arbitration. So the fewer arbitrators you have, usually the cheaper it's going to be. But sometimes you want to have the extra people, and those arbitrators are typically going to be professionals, usually lawyers and former judges who have backgrounds in particular areas. The parties can agree to the mediators that they're going to select. If there's three, maybe one person picks one and one other person picks the other,
Right.
and then maybe the third is sort of a combination of agreement on that.
What we're continuing again with business attorney Brian King. BusinessLawAttorney.com. BusinessAttorneyLaw.com. BusinessAttorneyLaw.com. We've got it up on the screen. Click. You'll be there. Brian, have you sat in front of an arbitrator, an arbitration panel, and what is it like for an attorney?
I have. I mean, it's usually it's a little less formal than the court system is.
Mm-hmm.
And again, it depends on their rules and how they want to do it. Sometimes the rules of evidence apply, like the same rules of evidence that apply in court can apply, or the parties can waive some of those objections and just present documents just like maybe you or I would if we were just talking about documents. And so, it's a little less formal, and some, like I said, it could be faster because you don't have as many objections.
I follow you. You mentioned that they have to be paid, these attorneys, former judges. Is it the company that pays? Is it in the case, would it be an employee who pays? How does that work?
It depends on what the contract says. Sometimes it'll say the prevailing party pays. Sometimes it'll say that the parties will split the cost.
Okay.
And so if it doesn't say, then the parties most likely are going to split the cost.
Okay.
So,
well, that's reasonable.
Yeah, and so you want to have those provisions in your document, in your contract, whether you're going to wind up in court, whether that sort of, sometimes that will make people nervous being in court anyway because of the formality of it. And so arbitration and mediation, they've both been alternative dispute resolution mechanisms that have come into play largely over the past, say 10, 15 years. They've gotten more popular.
Sure. And explain what the difference is between mediation and arbitration.
Okay. So the mediation is non-binding dispute resolution. So you go before a mediator, you talk with the mediator about, maybe sometimes the mediator may meet with one party and then go over and meet with the other party, find out what their sides
Okay.
are, and then may have them come back to a group, a joint session where he talks to both parties. Sometimes he keeps them separate. The time just depends on what the mediator, in his experience, and what the matter's about, how he wants to do that, and then he tries to see if the parties can reach a resolution. And then they would sign a settlement agreement,
Sure.
and then that settlement agreement, if it would be enforceable.
And is it typically employer-employee, or what would be some other instances for the need?
It could be any type of contract. It could be, if you say a company and a vendor that they're using, maybe a dispute over supplies or something like that, and they could go to mediation if that was in their contract. Oftentimes, though, the court system has now implemented mediation as a mandatory process that you have to go through in the Augusta Judicial Circuit and I believe the Columbia, the new Columbia Judicial Circuit.
I had heard that.
Yeah. And so you file a lawsuit, and pretty soon you're going to be mediating it, and because it could clear the court docket. The court doesn't have to get involved if you settle it yourself. Sometimes that's all it takes is people to get kind of face to face and come to some resolution. Sometimes it doesn't work out that way. So
that's very true. Again, it's businessattorneylaw.com, businessattorneylaw.com. Brian King serves clients in both Georgia and South Carolina. And before we scoot, have you drafted any agreements for companies in which it was not arbitration or mediation, but that there's a particular court system, court jurisdiction?
Well, right, yeah. So if you're gonna if you're gonna be going to court, you want to state where you're going to be going to court, and that's usually called venue. So whether it's going to be Columbia County or Richmond County or wherever else, because sometimes if you don't specify and the other party is in another state, you may wind up litigating in that other state depending on what has transpired. But if you've got it set forth in your agreement where you're going to be, you don't have to worry about that. You don't have to worry about hiring an attorney in another state and traveling to that other state. Makes
sense. Well, these are just different, alternative forms of solving some disputes, because they will come up for sure. And again, Brian King, businessattorneylaw.com. We are appreciative of the boys here at getupproductions.com who take care of the podcasting for us, and there's information up on the screen if your company would like to share your message in a creative way to do so. They're located in the Augusta area in downtown Augusta. And we are pleased to welcome back into the program attorney Brian King. How are you, Brian?
Doing well, thanks.
Fantastic. As we cover a lot of business news with Augusta Business Daily, we're hearing a lot more about people wanting to back other people in business. Maybe it had to do with the COVID situation, but it seems the people who are maybe not in jobs now are becoming entrepreneurs. Are you hearing a bit of the same too?
Well, that's right. A lot of people have started businesses and invested in other people's businesses and helped other people get started. And I represent both, the people who are wanting to invest and the people who are companies who are seeking investors. So we can talk about that from both perspectives. But sometimes the person who's looking to invest money, they're looking for a set return on their money. Maybe they want to do a promissory note where they're loaning a certain amount of money to the company and then expect to be paid back over time with a certain set interest rate. Sometimes it can be that they're wanting to actually have an equity stake in the company. Maybe they get a small stake like 5%, 10% or something like that. But the risk is the company may go bankrupt or go out of business, and they may not get that money back. And as you know, like when a company does dissolve, the creditors that get paid first are going to be the non-equity creditors, so the contract holders or promissory note holders and that sort of thing.
Employees would get paid first, maybe?
Well, the employees are going to get paid. Yeah, that's a debt of the business that's going to be paid because you've got to pay your employees. So
yeah. Makes great sense. What are some questions, looking at first from the investment side?
Yeah.
What should an investor ask an entrepreneur about their business to get the entrepreneur to maybe convince them?
Yeah, well, I think that the investor should understand the business and know what they're. It's like Warren Buffett says when he talks about investing. He says he never invests in anything that he doesn't understand. And so take that advice and run with it, and get financial statements from the business. See how well it's been doing over the past years. If it's a existing business and not just a startup.
Yeah.
And ask for copies of the tax returns. If you've got a couple years tax returns, you can tell a lot about the company. Look at how much the owner is paying themselves. How much are they taking from the business, and and then maybe have some. You may want to have an employment agreement with the owner to kind of set that salary so that they're not taking more than maybe you think they should.
That's kind of risk and reward if they have more skin in the game.
Yeah,
maybe.
Yeah. So you may even want to set their pay on a performance basis, or at least part of their pay.
Sure.
If the company does well, they do well.
Yeah.
Because that's what you're looking for as an investor. You're looking for a return on your investment.
Yeah. And again, Brian's website is businessattorneylaw.com, businessattorneylaw.com. And then look at it the other way. Let's say I had a business, or let's say it's Augusta Business Daily, and I was trying to seek some extra capital.
Right.
What qualities should I look for in a partner or an investor?
Yeah, well, that's it. Partnerships or involvements with other people. When you invite other people in your business, you want to have people that you can trust, and you want them to trust you. It can make the biggest difference, in terms of being able to work well together. And even if you're not really, the investor may not be working in the business, but you're going to have conversations about the business. You're going to, where is the business going? What that sort of thing. And so as a company trying to raise funds, I mean, you could, issue debt by selling, or having promissory notes where you're going to pay back that money over time. And maybe you want to say, well, I'll take this money right now and I'll start paying you back a year from now, or 2 years from now, or whatever. Or when I hit a certain benchmark, then I'll start repaying the money, and making sure that they're on the same page with that. And sometimes getting a loan from a private investor can be a lot easier than going through, like, say, the SBA to get a loan. Now, a lot of clients have gotten loans from the SBA over this, the COVID time. And, it's in addition to the stimulus funds, I mean, there were a lot of funds where you could borrow from the SBA. Now, with the SBA comes a lot of oversight. If you're getting a loan from them, they're going to want to see all your financials. You're going to have to basically open up everything, and show them and convince them to loan you the money. And then you're going to have to report every year on what your financials look like and how you're coming along and repaying that money or taking steps to do that. And so, sometimes business owners don't want to go the SBA route because of all of that oversight and frankly, paperwork. And so it's much easier when you have a private investor to invest in that way anyway. And so, that's something I talk with my clients about is, the different options when it comes to raising funds, and whether they want to go an SBA route or a private investment, and then whether they want to sell equity to a potential investor, and so equity or debt.
That's an interesting point because I bet the person giving the money thinks that the business is worth differently than the person that runs the business.
Of course, that
and
always happens.
How do you work that out?
Well, that always happens. And what I tell people is, what you see is what you get. You look at the financials, and it's not what the company is going to be worth 10 years from now. It's what it's worth now. And because of the investment that the investor's putting in, it might be worth this in 10 years.
Yeah.
And
okay.
see, sometimes the owner is thinking, well, it's worth so much more than what the financials are showing because of all these things we're going to do. But they can't get to that point without the investment.
Yeah.
And so the investor wants to take that risk with that money to say, okay, I'm willing to make this investment.
Yeah, but what's the reward?
I'm going to share in that reward.
Yeah.
Right.
And
right.
that, you know what? That's reasonable. That's totally fair. You ever haggle with an opposing attorney, meaning the business owner and the investor? Have you been in those kinds of negotiations?
Yeah, we've talked about that as far as the value of the business, and whether it. I mean, there's been times when I've represented investors into a business or someone buying a business, even buying the whole business, because that's just another version of investing in a business, right? Buy the whole business, right?
Yeah.
And we've looked at the financials and what the plan for the business was, and just had to have a frank discussion with my client that this business is not worth what you were thinking about paying for it. And sometimes we negotiate and we get the price down, and I've saved my clients lots of money for that. And now sometimes the business brokers aren't happy because they're getting paid based on the percentage of the purchase price. They don't want the purchase price to come down.
Right.
And, but I'm representing my client in that transaction, and I've just got to do what's best for them. And a lot of times it's not just the purchase price that we're negotiating. We're negotiating the terms, whether there's a non-compete or not, whether how long that's going to be, and all kinds of things, really, because the purchase agreements are several pages long. And they're going to, whether there's going to be a consulting period, for example, is the old owner going to stay on for a 3-month period or 6-month period?
And what's that worth?
Yeah,
right?
And how we're going to pay? Is he going to get paid something for that, or is the purchase price alone going to be enough? And sometimes though the purchasers don't want to have. They want the old person gone. They
Bye everybody. Hit the beach, right?
Exactly. So they're ready for them to get out, and so they can start running things the way they want to run them.
Yeah.
So it really just depends.
Well, another good reason to have Brian King in your corner to get started, please visit businessattorneylaw.com. A lot of really good information. He's also a thought leader on Augusta Business Daily, and he's developing really quite an archive of articles and podcasts. And Brian, thank you so much for what you do. And thanks to the folks at GetUpProductions.com, the hosts of our programs here in downtown Augusta. All the information up on the screen. They'd love to talk to you if you'd like to share your messages and try to improve your business as well. Well, we're continuing with Brian King, and we're continuing on probably arguably the most important part of business, which is money, right?
That's why you do business.
Without it, I mean, it's pretty tough to operate and continue to move your business forward. And there's so many different ways to get money, but I know I've gone to family before. I've gone to friends before. Have you dealt with those situations on behalf of a client? And is it true that you should never mix family and money, or can it work out?
Well, it can sometimes, but it's not usually what I would suggest, because you've got to see that person when you go to Thanksgiving and Christmas and all of that. So they're looking over at you like, well, how are you doing with the business? It's like, where's that return? And so it can be uncomfortable. But it has worked out where people have made money for their family, has done really well, and and it works out well. But it can be in the form of a loan from a family member, or you could give them an equity stake in the company. But even though some people are supposed to be sort of like limited partners or silent partners, that silent is not always, they're not always as silent as you may want them to be. So
they're silent if you paid them money.
right.
They're silent.
Yeah.
But I could see the pitfalls for sure in trying to raise the money. And you mentioned sometimes it's kind of a loan. I mean, has Uncle John asked for a promissory note from Jimmy if he loans money?
Yeah, I mean, I recommend it, because that way the agreement is in writing, and I think it's good for both parties, really.
Okay.
And if it's over $10,000, it really needs to be in writing for tax purposes anyway.
I see.
And there does need to be an interest rate of at least the minimum applicable, they call it the AFR, applicable federal rate.
Is that over the prime interest
No,
rate?
it's actually pretty low usually, and it's between related parties, so like a family member or, So the IRS requires you to charge some interest at that level, and but it's good for that, and it's good for the parties. Just know what the agreement is, know when the payment is going to be due. If it's monthly payments, what date they're due. Is there a late fee if you don't pay in time? That sort of thing, maybe the person investing into the company, maybe you want to have advances in your language where they can loan additional sums if you need it. Maybe there's a certain, it's not quite a line of credit, but it's, you can go to them and say, hey, I'd like to get some more money on these same terms that we've already agreed upon. And sometimes that they will do that.
We're continuing with Brian King, and he's online at businessattorneylaw.com, helping clients with business transactions really in both Georgia as well as South Carolina. So there's the family route. Do some folks just run up the credit card? Have you heard that too?
There's been a lot of business owners who've started business with credit cards. Sometimes, you've probably seen these 0% offers for 6 months or a year sometimes.
Yeah.
And that's money that's available that you could use for that, and you just got to make sure you pay that off at the end of that time. Because otherwise you're going to be looking at 20% interest or so. You definitely don't want to carry that rate of interest. But between then and the time when it's to pay it off, you could get a bank loan to sort of refinance that debt at a much lower interest rate, because after say 3 to 6 months, you've got some return, you've got some business to show the bank, to maybe where they will loan you the money.
Now, you've been an attorney for 20 years. These are kind of unprecedented times. Have you noticed that banks are more willing the last couple of years because of COVID, or less willing?
It kind of depends. I would say, with say SBA loans, the SBA will back up to 50% of the loan for the bank. Okay. So in those instances, I would say banks are pretty willing to, as long as there's a good business plan and there's assets. Largely banks are looking for assets,
collateral.
Collateral, right? If they have to foreclose on that loan, they've got something to go after and to show for that. So whether it's a building, a lot of business owners have to put up their house as collateral, like a second mortgage.
Sure.
Or if, they have any other assets,
own
or
a
like
car even,
retirement accounts and such like that, and some people do borrow from their 401k to put into their business. So there's lots of options, and you just want to make sure you're not paying too much interest and you've got a good plan for paying that back.
Okay, sure. Makes perfect sense. We're continuing with Brian King and looking at different ways to kind of raise money for the business. Have there been more private loans that you've noticed maybe as well over time?
I don't know if it's been more, but there are a lot of those, and with the whole say .com, back in the early, say, I guess late 1990s,
right?
And then in the 2000s and all, and then you saw you had the .com bust.
That's right.
And then you had the real estate bust in 2008, and also there's some ebb and flow when it comes to business cycles. And a lot of people think, well, I'm gonna try to raise this money, and I'm gonna sell equity. I'm gonna sell shares in my company, and and there's all these crowdfunding ideas, where people just say, okay, well, hey, I want some money, and they do a little video and they put it on these crowdfunding sites, and people just give them money or whatever.
I hadn't thought of that.
And and that's an interesting idea, but I'm not giving my money to some idea unless there's some return, that I'm looking at. So
Sure.
And so I've done, private offerings for my clients where they've, sold shares in their company to raise funds and all, and that's worked out fine. And a lot of times it's people knowing other people with money who are looking to invest. And if you know those types of people, it's much easier to raise funds versus just sort of a general solicitation out there,
Right.
But you can go about it in that manner if you want, and I can set things up to do it that way. You just have to comply with the securities laws, both the federal and the state. And the documents are, pretty thick.
Sure.
That you have to disclose everything that you can think of as what could go wrong, because you are making representations to these potential investors about what your company is going to do to be able to pay them back, and what assets it has currently, and all of that.
And lastly, before we head out, we live in a Shark Tank society,
Right,
and I've heard of these angel investors. For those who don't know, how would you define who an angel investor is, and is it much different from just a private person lending money?
It's different in the sense that some of the angel investors are almost like professional investors. They're looking for deals that they can invest in, and so that's the biggest difference. I mean, they're sophisticated investors, unlike say going to Uncle Bob and saying, "Hey, will you let me have some money to put in my business?" So they're usually looking at. I've been to some angel investment presentations and stuff just to kind of get a better feel for what they're doing and what they're looking for, and the person who's looking for the investment, they'll do a presentation like a Shark Tank presentation.
That'd be fun.
And they'll it's very similar to that, and they'll get posed with questions about their business, and and some of them do walk away with an investment, and of course it's subject to drafting the documents. They'll have attorneys draft the documents, but it's definitely a way of doing it, because those are the type people that you're looking to get money from. They have the money, they're looking for an investment. If you've got a great idea, it's a good shot to do it.
Would they provide more than just money as well?
Sometimes they do. Sometimes, just like the sharks talk about how they bring to the table all this experience that they have, and they do. Some of those
Fubu. Was that
Damien? Yeah, he. Sometimes the angel investors do want to kind of take an active role in it. Sometimes they don't. Sometimes they just want to be that silent partner that sits back and gets the return. So
and was this in Augusta that you went to the meeting?
The one that I actually went to that was really good was in Greenville, but I did go to an event at AU one time where they had sort of a Shark Tank presentation where some investors here, or so they kind of got on this panel, and they would ask them questions, and the companies would present.
So it might be good to Google angel investors of Georgia and South Carolina. One way is look if you're looking for money. Of course, there's family, private loans, there's credit card, crowdfund sourcing, banks, SBAs, but get some guidance if you can from an attorney like Brian King as you move forward and prevent some mistakes for sure. Start by going online to businessattorneylaw.com. Brian, that was great. Thank you so much.
Thank you.
Okay.